on time, never mind. I'm going to call the case, and so whenever you're ready to start with the transcription, I'm ready to go.
I'm ready, thank you.
Great. This is case number 23-000-083-MZ, the City of Grand Rapids against the Michigan Department of Civil Rights and the Michigan Civil Rights Commission. We're here today to deal with a motion for summary disposition filed by both of the defendants. They are seeking summary disposition under both MCR 2.116C4 and 2.116C8. The C4 request has to do with the jurisdiction of the Court of Claims. The C8 request has to do with a failure to state a claim on which relief can be granted. I've received a motion and a brief, a response that was filed on July 27th, 2023, a reply brief. Oh, I'm sorry. The motion itself was on 7/27/2023. That was the plaintiff's response to the motion of 7/27/2023. Then a reply brief. In addition to that, I received a corrected amicus curiae brief of the American Civil Liberties Union of Michigan, which bears the date of August 7, 2023. And then the plaintiff filed a brief in response to the amicus brief. I've had the opportunity to read both of those. Obviously, an amicus is not a participating party. And so the American Civil Liberties Union of Michigan does not have a right to present oral argument, but I've considered the arguments that they've made along with everything else. Now, let me start out by explaining what I think is going on here, and then you can tell me where I'm wrong. There was, it probably still is, an investigation being conducted by the Michigan Department of Civil Rights in regard to the Grand Rapids Police Department and the alleged mistreatment of citizens of Grand Rapids. Now, at least as far as I can tell, this probably goes all the way back to about 2017. I may be off a little bit, but suffice it to say, it's been around a good long while. Now, in the course of that investigation, there are individual complainants who have told their stories to the Michigan Civil Rights Commission. And in the course of hearing those stories, the defendants have asked for responses from the city of Grand Rapids. And apparently the city of Grand Rapids has provided responses on many occasions, but at least as far as I can tell, not a single complaint has resulted in formal action that's reached the stage of a final determination. What has happened is that there were several matters conducted at the administrative level, but before any final order was entered at the agency level, the city of Grand Rapids at least 3 times attempted to obtain appellate review in the Kent County Circuit Court, which is technically the 17th Circuit Court. In 2 of those instances, on March 30th of 2023, Kent County Circuit Judge J. Joseph Rossi denied the city's application for leave to appeal. And in the 3rd matter, there was a stipulation in order to withdraw an application for leave to appeal that had wound up on the docket of Kent County Circuit Judge George J. Quist. Now, it's fair to say that investigations are still in progress. And so the city of Grand Rapids wants to call the question and get the Court of Claims to issue either declaratory relief or an injunction that prohibits the defendants from pursuing any matters that are more than 3 years old. Where do they get the 3 years from? There's a statute of limitations contained in the Revised Judicature Act, MCL 700.5805, which prescribes a general 3-year statute of limitations in most personal injury actions. Now, I can make some observations at the outset because I've been a judge on the Court of Claims for only a few months, but there's a certain pattern of what we get here. The Kent County Circuit Court, like all the other circuit courts in the state, is a court of general jurisdiction. The Court of Claims is a court of limited jurisdiction. And because of that, we wind up getting all sorts of jurisdictional challenges all the time. And one of the most common forms of jurisdictionally defective requests is when people bring their general gripes to us and asked us to issue a declaratory judgment. I can't tell you how many times already I've had to deal with declaratory requests for declaratory relief that have nothing to do with what the Court of Claims is supposed to be doing. I'm not saying that this one has nothing to do with what the Court of Claims is supposed to be doing, but I am going to make the observation right out of the box that whenever anything's an administrative proceeding, the Court of Claims jurisdiction is questionable at best and absent in almost every case. Now, there are a couple of other concerns I have about the case. First of all, as a general proposition, you cannot obtain an injunction against a governmental official. Courts can't do that. The Davis case from the Court of Appeals, 296 Mishap something that I cite all the time says, as an absolute last resort, when you've tried every single other thing you can do, then maybe, just maybe, a court can issue an injunction against an officer or an agency of either the legislative or the executive branch. Why are we supposed to be so careful? Separation of powers. And I've done a lot of reading on that before today, and then I did a little bit more just to get up to speed again today. The second thing I'm concerned about is that when people come to us with declaratory relief requests, what they're really doing is they're trying to get around a mandamus request, because mandamus is much harder to obtain. Mandamus, you have to show that some state official is refusing to carry out a clear legal duty. And so time and time again, people ask for declaratory relief when really the one and only thing they can get is mandamus. This sort of might be there, but there's no way that what's happening at the administrative level could ever be the subject of mandamus. Then there's the separate problem of the fact that the statute of limitations is an affirmative defense that's got to be pleaded. Now, whenever you have an affirmative defense, the odds of any court granting declaratory relief are very, very low, because an affirmative defense, of course, could be waived. Why would we get involved when there hasn't actually been a formal statement of affirmative defense somewhere, much less outside of our court? Then I have a concern because the statute of limitations generally has to be applied in a factual context. Here, at least as far as I can tell, it looks like an abstraction, because the city says, until a charge is made by the MDCR, there is no contested case hearing and consequently no administrative remedy available to plaintiff. At this juncture, all pending complaints against the city of Grand Rapids are in the investigative stage of the MDCR's process. This leaves plaintiff with no administrative avenue for relief in those pending cases. Yes, and it also leaves this court with no factual context to determine whether the statute of limitation is run, because I don't even know what we're talking about as far as accrual. And then finally, it just seems to me that there is an appeal process out of the administrative agency proceedings. Of course, it involves, at least at this stage, or now there's nothing pending that you could file on, but there's an application process to the circuit court. And if you lose there, there's an application process to the Court of Appeals. And although I do see agency matters all the time when I'm wearing my other hat as a Court of Appeals judge, if I take this case on and I find that I have jurisdiction, it would be the very first time I or any of my colleagues has ever dealt with anything that's in the maw of administrative review. So Ms. Fossil, you really have your work cut out for you today. I think this case has absolutely no business in the Court of Claims. You're welcome to try to persuade me otherwise. You persuaded me otherwise when I was a circuit judge on a couple of occasions, but I'm mindful of my role here as sitting on a court of limited jurisdiction as opposed to the general jurisdiction of the circuit court. So why don't I let you go first, Ms. Pendrick? But suffice it to say, if you could see all the stuff I have up here, you know I've done a lot of reading getting ready for this one, because I've inherited a docket that is just massive. And one of the things I've learned is I got to start deciding things from the bench. because these cases need to move. So go ahead, come on up. Let's get you on the microphone so that the court reporter can hear you.
Can you hear me okay?
Yep, why don't you identify yourself for her?
This is Kim Pendrick appearing on behalf of the Michigan Department of Civil Rights.
And I had your P number right?
You did have my P.
Okay, so go ahead. Tell me, let's talk about C4 first, and then let's talk about C8.
Well, as to the jurisdictional prong, the court has made some comments that I understand that the court understands the issue, so I won't spend too much time on it.
Yeah, I'm spending half my life on the Court of Claims just dealing with C4 motions.
Yeah, and what happens is we recognize the Court of Claims has jurisdiction over actions against the state. I file motions all the time trying to get cases out of the circuit court into the Court of Claims.
Sure.
But this is different. This is before an administrative body. This court could hear something that was before an administrative body in some circumstances. For example, if the city of Grand Rapids was arguing that we were applying a statute that was unconstitutional, this court can take that.
Sure.
And decide that, but they're not alleging that here. They're not alleging the statute's unconstitutional.
No,
This case
this is process at the administrative level. To my mind, this is no different than somebody who's a claimant for unemployment benefits having some evidence excluded at a hearing and trying to file a declaratory judgment action in the Court of Claims. I mean,
yeah, exactly.
It's essentially a mid-course dispute in an administrative agency. And there are so many garden variety disputes like this that if we started taking these on as a matter of declaratory relief, we would be inundated. I mean, I can't tell you how many disgruntled people from agency proceedings want to come running to the Court of Claims when they don't like what's happening.
Right. And a lot of times they just want to get around the administrative process. Maybe they don't even file in an administrative process, and that's where they should have been. So you don't have to wait for an order to be entered for this court to decide that this should not properly be before it. It can go to the MDCR. It will be reviewed by an ALJ, decided by an ALJ. They make recommendations to the commission, which will then look at the decision to make its finding. And if all else fails and the city of Grand Rapids still believes they're correct and the administrative bodies are incorrect, they have the appellate process. So they'll get to the Court of Appeals.
And just to be clear, at least as we sit here today, or you stand here today, it has yet to be the case that the agency process has resulted in any sort of adverse determination or action against the city of Grand Rapids.
There were 2 cases where charges were filed. But those have been dismissed.
As I understand it, there's nothing live right now.
Well, there's one case that's under investigation, but no charge.
Right. My point is, you haven't proceeded all the way to the end and made not you, but the defendants haven't proceeded all the way to the end and made any kind of adverse determination. As a matter of fact, that seems to be one of their main gripes, that they have nothing they can go to the circuit court of right on, right?
Yeah, it appears the city wants things to go faster and they want a decision before they go through the hearing process, but that's not a futility argument. That's a economy argument that's not been held that I found as an exception.
I want to give them some credit on that though, because it seems to me that they feel like this investigation is going to be hanging over them for years, if not decades. And when does this ever come to an end?
Well, it has not taken decades to my knowledge.
Well, I think it started in 2017.
The MDCR generally has a rule that they try to complete their investigations within 6 months. That doesn't always happen. Things cause delays. Currently, the one pending case and investigation that's over 3 years old has stayed because of this hearing today. We went to the circuit court to get a show cause order to compel the city to give discovery to the investigator. And we went before the court. I asked the court to let discovery keep moving forward and the hearing keep moving forward, but the court stayed it. So there is a case that stayed, and that's another delay that can happen in a justifiable way that takes a case beyond 3 years. And since the court's familiar with the jurisdictional argument, there were a couple.
Right, but as far as pure jurisdiction, the fundamental problem in your view is that this is in the first instance within the purview of the agency. And then if there is some sort of final determination ever on one of these claims, then of necessity, the review is through the circuit court up to the Court of Appeals.
Correct. And there was a case that I had found recently. It's cited in the briefs too, the judges of the 74th district case, where they indicated administrative agencies are competent to decide jurisdictional issues. That's what this is. So this court should let the agency decide how to apply the rules applicable to the process that's set up administratively. This court doesn't need to do it for them.
All right, and it's your view, not that it's my business, but it's your view, I think, that they're complying with their own internal regulations about how to run their proceedings.
Correct.
And I guess if they're not, the remedy that the city has is to complain inside the proceedings and then take it to the circuit court.
Correct.
And I'm sure you'll concede that if there's ever a final determination on any one of these claims, that they have an appeal of right to the circuit court.
And they can apply for interlocutory appeal, which they did in the 2 cases where
Right.
ALJs found the 3-year statute was
Right.
not applicable.
Oh, sure, right.
So you can, but that's, permissive. It's not.
Oh, right. I mean, one of my great frustrations, having grown up in the federal system and now being a judge in the state system, is we're way too permissive on apps for leave. I wish we were more.
I'm sorry, way too permissive.
On apps, APPS, applications for leave. Sorry, that's shorthand. All right, so talk to me about your C8 argument, because I think that I buy that too, but I just want to make sure I understand it, because what you're saying is the statute of limitations at issue here is one borrowed from the Revised Judicature Act. It's not something that is within the Elliott Larson Civil Rights Act.
Correct. The Elliott.
And so if you want to figure out whether you ought to apply the statute of limitations in an administrative proceeding, you don't really want to think about the purpose of the Elliott Larson Civil Rights Act. You want to think about the purpose of the Revised Judicature Act. And I've got some quotes from the Michigan Supreme Court on that. And basically they say the point of the Revised Judicature Act was to clean up proceedings in civil and criminal cases in the court system, not
Right.
to tell administrative agencies what to do. Because, I mean, there are all sorts of procedural features in the Revised Judicature Act that if you applied them to agencies would change agency procedures pretty dramatically. Yes?
And I think the problem with setting a 3-year statute of limitations on what is essentially a notice that you're going to a hearing, which occurs after the end of discovery, is that it puts the respondents in a position of delaying the proceeding.
Right.
So once we get a complaint filed within 180 days,
Right.
if the court says they have to complete the investigation and file a charge within 3 years, most of the time that occurs. But there are cases where it doesn't. A bankruptcy proceeding could stay something. We have a stay right now because of this case. It took the city 8 months to respond to the charge in the one pending IAEA case, and that's 1/3 of the time that we would have to bring a charge.
Right.
So the concern is also to the claimants who are going before the Michigan Department of Civil Rights alleging race discrimination or
Yep.
some other type of discrimination. Their claims aren't told during the administrative proceeding. So they
Right.
have a choice. They go administratively or they go to court where there's a 3-year statute of limitations for them to file their own civil action.
Right. So in essence, then, the city is deriving a benefit from the delay. The benefit it's deriving from the delay is that it's not going to be sued by these individual claimants, because although the statute of limitations doesn't run in the administrative proceeding, it does run if they were to ever want to file a lawsuit. And the consequence of that is a lot of these people are already out of time and barred by the statute of limitations from filing their own Elliott Larson Civil Rights Act claims in the circuit court.
Right. Right. If 3 years has passed, that would be the problem they had.
So it's not all burden and no benefit for the city.
Correct.
The benefit is that the statute of limitations is still running and it's not told during the administrative proceedings. That old Michigan Supreme Court decision says that.
Right. One of the claimants who withdrew her claim was able to file a lawsuit because she was a minor. So she got to use one of the
Yeah,
savings
right. I
provisions
saw
to
that.
file in circuit court. But no, if we have an adult claimant, they would be out of luck unless they knew to withdraw before the 3 years was up and pursue their claim civilly. And some of these people can't do that. They might not have a case that's good enough for a lawyer to invest time in. They
Sure.
couldn't get counsel. So the administrative process, they have a lot of complaints, sometimes staffing issues. So we can't always guarantee an investigation to be completed in 3 years, even though that's the goal. The goal
Right.
is to be within 6 months, but.
Right, but for purposes of C8, I think the only thing I can really consider is whether trying to use that 3-year Revised Judicature Act statute of limitations in the administrative proceeding is trying to drive a round peg into a square hole, right?
Yeah, and I think the problem, if you compare the administrative process with the process in a civil lawsuit, they're very similar. You have a statute of limitations to file a complaint. Administratively, it's 180 days. And if you're filing it in circuit court, you have 3 years. So that's the statute of limitations to start the claim. Then in a legal proceeding, they have discovery. That could take a long time. I recently had a case that lasted 7 years after the filing of a complaint.
We can all tell tales about that kind of thing.
So, but what the city's argument is if you put this in the context of a civil lawsuit, is you have so much time to file your complaint, but then you have a limit to when you have to get everything done before you try the case. That's what the charge does. When the agency issues a charge, it's finished. It has done all of its discovery. It's interviewed witnesses. It's gotten records. It's now saying, we're charging you and you can go to a hearing before the Michigan Office of Administrative Hearing and Rules. And that's where it goes. So it's a really late in the game time, and the statute of limitations, our argument is met when the claimant files within a really short 180-day window. They have much less time to file an administrative charge than they do a lawsuit, which gives the city more time to put in litigation holds, preserve records, talk to witnesses, and do whatever they need to do to make sure that claim doesn't get stale.
I got it. So what you're suggesting is the way the administrative process is set up, it's a ready, aim, fire system, whereas civil litigation is a ready, fire, aim system. That certainly is how it seemed to me as an observer of it.
Yes.
Okay, I got it.
So that's what I have. If the court has any questions, I'm happy to answer them. There was also a count that we moved to dismiss that they alleged that IAEA had to refile when he turned 18 under a savings statute, but I didn't see a response to that. So I think it's abandoned.
Not sure, but the main problem here is a jurisdictional problem anyway. I mean, look, the Court of Claims has a job to do. And I mean, Ms. Fossil is going to try to persuade me otherwise, but this is not our job.
Okay. All right. Well, thank you.
Okay, thank you.
Thank you.
Sorry, Ms. Fossil, I don't mean to be so wildly skeptical, but I fear the flood if I rule in your favor here. I mean, you can't even imagine all the stuff we'll have to start hearing.
Your Honor, I don't think you should fear any flood from this, quite
You
frankly.
can't, yeah, we're already getting those cases, but thankfully we throw
Well,
them all out
But they're
because,
not like this case.
okay,
This case is all about determining the party's rights going forward. That is the purpose of a declaratory judgment action. If the statute of limitation applies to administrative actions brought by the MDCR,
Right.
then they would be unjustified in moving forward with cases that are older than that. Yes, they could do it and we could not waive it. I suppose that would still be a good faith effort on their part, although I would question it. But the problem that we're having here is we are now in a position, when I started this back in, whenever I filed this action here in the Court of Claims, at that time we had 13 cases, 3 of which were already charged and were over the 3-year limit, and 10 of which had not progressed to a charge and were just sitting in limbo and are still sitting in limbo on this. I do want to, I probably should digress right now to get to this IAEA case, because I think we have a fundamental difference of why this is an issue in the case, okay? We're not saying that Mr. Jesus Yanez, who was the minor in this case,
Right.
once he turned 18, had to refile with the MDCR. We're not saying that. We're only saying that he is now 20, and it's very clear under the tolling provisions of the statute of limitations that he had till he was 19 to bring a federal action. So he can't even bring a federal action here. Yet he's sitting in the MDCR and able to get the exact same relief, compensation for injury under the statute, that he cannot get in any other form in this state.
well, just to be clear about it, I mean, he's the one identified in the ACLU amicus
Yes.
brief. They tell this story from start to finish. Well,
Yes.
I don't understand what the grave injustice would be. I mean, let's say, for example, that the legislature, these days it might, just says, you know what? Statute of limitations is way too short for civil rights complaints. We're going to blow it out to 20 years. How is that situation any different than the complaint you're making here? I mean, you seem to suggest that there's some sort of automatic right to have it thrown out at the 3-year mark, no matter what happens. You said the only place you can bring this action now is in the commission, right?
Right.
But I mean, if the state of Michigan expanded the statute of limitations to 20 years, then he could just file it in the circuit court, right?
But it hasn't.
No, I understand that, but it's always going to be the case that there's going to be some forum where you can bring a claim, even though you'd be foreclosed in a lot of other fora. I don't see why that's a problem.
Well, I can tell you that this has never been decided by a Michigan court.
Mhm.
This is a case of first impression. And when it's a case of first impression, it is appropriate to look at what other states have done. And several other states have looked at this exact issue and said, either we're going to apply the statute of limitations by analogy to administrative actions, which could happen in this case, or we read the statute of limitations to actually apply. So for example, in the Kentucky case that we cited in our brief, whose name I will forget unless I look it up.
That's okay.
Okay, the Kentucky case, there was a 7-year statute of limitation on reclamation of forfeiture bonds.
Right.
And someone tried to do this after 10 years, and the court said, well, you know, this is a little iffy, especially since there's a 7-year statute of limitations. The plaintiff said, no, it doesn't apply. It only applies to judicial actions. Exactly what's been said here.
Right.
And the court said, wait a minute, we have to consider the underlying purposes of the statute of limitations because we are jeopardizing any defendant who is subjected to litigation on an ongoing basis. Let me give you one example.
Well, right. Well, hang on just a second, because I want to push back on you on that point. I am considering the purpose of the statute of limitations. It's contained in the Revised Judicature Act. It's borrowed. And the Revised Judicature Act is very clear that the purpose, when it was enacted, and still to this day, is to regularize and make more efficient the operations in courts of the state.
Yep. And what do you think an ALJ does? I think that an ALJ, an administrative law judge, functions in exactly the same way as a circuit court judge in deciding these issues.
But
They
there
take
are all sorts
testimony.
of agency proceedings where the rules of evidence don't apply.
I beg your pardon?
There are all sorts of administrative proceedings and where the rules of evidence don't apply. Why wouldn't they be bound by those too? I mean, you can't just import all of the rules that govern court proceedings and say, by analogy, they all apply if it's advantageous to us in administrative
But
proceedings.
this is a question of fundamental fairness. This is a question of due process for defendants that are out there. The MDCR, I don't know if you got a chance to read my response to the ACLU's.
Yep, I did. I
amicus.
read everything.
Okay, great. Then you know that there was recently, last August, an Auditor General's report on the MDCR criticizing it for the fact that it was so tardy in processing these claims. And it pointed out that at that time, there were 276 claims that were over 3 years old. Now I'll tell you, in one of those claims, because 13 of them were ours, right?
Mhm.
In one of those claims, the claimant died. We have no ability to determine what she would have said about the nature of her claim or her damages. We have no ability to do that now because the process with the MDCR is not like discovery. That's one thing that's different. And I'm talking about the MDCR investigation
Yep.
versus the ALJ's role in this. But the MDCR's investigation is not like discovery. It's not a two-way street.
Right.
We don't get to find out what evidence they have. As I think somebody was just saying, it's a ready, aim, fire, or ready, fire, aim
Yeah.
kind of process. And by the time they get to the charging decision, their ducks are lined up. We do not necessarily, unless the ALJ allows it, have the right to any discovery. And in these few cases that we've had, the ALJ decided that we didn't get.
Right, but if you talk about it as fundamental fairness, how's that any different than a situation where a criminal sexual conduct charge is filed against somebody 25 years after the incident occurred? And the statute of limitations happens to be extraordinarily long as opposed to inapplicable.
But there's a reason for that, and that is that very often those claims are undiscovered or unknown, or the victim is unwilling to come forward. These are claims where the victim or the victim's representative has come forward within 180 days, as
I
Ms.
understand.
Pendrick has pointed out. So
Right,
there,
but aren't you getting a benefit out of it in that they can't file a lawsuit once 3 years go by? It's not as if the statute of limitations is irrelevant or inapplicable. It just applies in one context, but not the other. I mean, all these people who've been around since 2017, 2018 as complainants, they can't file lawsuits against you anymore, right?
Well, the ones that were minors at the time still have.
Right, right.
an
But I mean,
ability to
that's a
do that.
savings provision.
Yes.
Right?
Yes.
But I mean, as each day goes by, more and more of these claimants are foreclosed from filing court actions, lawsuits, right?
True.
So the city gains a benefit there, and then the people are essentially stuck with dealing with the administrative process, which, as you described, and I read it in the popular press, I didn't have to read it in your brief, is wildly inefficient and slow. And so they're getting no justice at all, right?
They are not, neither are we.
I got it.
Neither is.
I understand, right? I mean, everybody's on tenterhooks waiting to find out what, when, if ever, the spirit's gonna move the commission to do something.
That's correct. And the problem is that as time goes by, memories fade, evidence is lost.
Sure.
You know, all of that, all of the
Sure.
problems that the statute of limitations was designed to resolve come to the fore and are unchecked.
I
And
understand.
that's why the courts in other states have said, we're either going to apply the statute of limitations directly to administrative actions, or we're going to do it by analogy. Now, we have in this state applied the statute of limitations to equitable actions long ago in way back in history
Sure.
by analogy. So we
Right.
have done it. There is precedent for
Right,
that.
right, but that's in court proceedings. That, are you talking about before the merger of law and equity?
No, that is in court proceedings. I'm not disagreeing with
Right.
you. But my point is that the courts have applied it by analogy when it was appropriate to do so. And what we are asking this court to do, and I believe firmly that it's within your subject
Right.
matter jurisdiction, is to declare the rights of the parties with respect to this question of law. This is not us fighting over the actual administrative cases.
I don't really
Or
have
tax.
anything to look at, though. I mean, I can't even figure out what an accrual date is for anything. I mean,
sorry?
I can't even figure out what an accrual date is for anything because I don't even have a case or controversy in front of me. I have an abstract question in front of me. And what I'm being asked to do essentially is render an advisory opinion that I'm supposed to say that they get 3 years and they only get 3 years without having any idea what that's tied to.
Well, it would be tied to at the very least, to the time that they are given, because this is the MDCR we're talking about, not the complainant.
Right.
By the time that they get the complaint itself, they have notice of the claim. That's the point
Sure.
at which it accrues.
Right, right. And I understand. I mean, your fundamental complaint is that the agency at the agency level has ruled that the statute of limitations is utterly inapplicable. And you want me to fix that. But if I fix it, I mean, do I then define what an accrual of one of these claims is? Do I leave it to the agency then to define when accrual occurs? I just feel like I'm going down a rabbit hole that's completely unsupported by any constitutional provision or statute. I'm applying something by analogy in a context where the analogy is not a good, clean fit.
I understand the problem. I would say that the court may be incorrect in saying there's no statutory basis for this. 600-5821 says that statute of limitations applicable to personal actions shall apply
Right.
to the states, the agencies, et cetera, when they're bringing a claim of this nature. So I think there is clear
Okay.
statutory
Okay.
authority for that under 5821.
Okay.
So what else can I answer for the court? Because I believe your opening comments pretty much made my overall argument unnecessary.
Well, I have to tell you, Ms. Fussell, I'm not trying to be hard on you. I'm just trying to survey my entire docket that I've inherited and see where there are jurisdictional problems that just prevent me from moving forward so I can devote more of my time to the merits-based claims that I have to deal with. I have lots and lots of those. I mean, I'm going to spend a month in August dealing with a bridge painting contract in trial. So I don't mean to make light of the plight of anybody else who's asking for relief here. I'm just telling you that I'm finding that these requests for us to exercise our authority to grant declaratory relief are so outsized compared to what I believe after 16 years on the bench, a declaratory judgment is supposed to settle.
Well, I can say that it's clear that if a declaratory judgment is meant to guide the parties in their actions going forward,
Right.
and the Court of Claims has jurisdiction over declaratory judgments for that purpose, which I believe it does under the statute, then that is what we are asking the court to do.
Well, I got it, but it's exactly backwards because you're not asking the court to define for you what your rights and duties are going forward. You're asking the Court of Claims to tell them what their rights and duties are. Typically, in a declaratory judgment action, you're worried that your activities may run afoul of some statutory obligation or contractual obligation. So you go to the court, and this used to happen all the time in the business docket with people who have restrictive covenants. Somebody bound by a restrictive covenant would come in and say, look, I don't want to get hung up in a breach of contract fight. Tell me at the front end that this is an unenforceable restrictive covenant, and then I can go about my business. You're not coming here on behalf of the city of Grand Rapids and asking me to tell the city what it can and can't do. You're in front of me asking me to tell them what to do.
But
Which is in effect, you're in effect asking for an injunction.
I understand your concern, Your Honor, but it also implicates the city's use of its own resources, which are taxpayer dollars. And we don't want to be going down a rabbit hole with raising the statute of limitations in every one of these instances when they finally get around, if they ever do, finally get around to issuing a charge. We know what the decision is going to be, then taking it up to the circuit court, the Court of Appeals, and so on.
Right.
If we had not been foreclosed by the fact that NDCR withdrew the charges in the cases that existed at the time, we would probably be in front of the circuit court by now,
Right.
and then the Court of Appeals. But we have no remedy whatsoever with respect to these ancient cases, other than to come to the court and ask for declaratory relief.
Right. And I get that, and I hear your frustration, and I understand the complications. I mean, the difficulty is that government inefficiency imposes external costs on people all the time. And what you're dealing with here, in my view, is more a function of government inefficiency than a failure of the system, because you can always seek leave by application to the circuit court. Unfortunately, those applications were denied. But there is a clear process, and obviously you, the city, understood that because you tried to invoke that process. Only after you failed in your effort to invoke that process in a shorter time frame than you would have liked if you come to the Court of Claims.
Only after the charges were dismissed and we have the pending charges remaining.
I got it. Well, but just to be clear about this, you say your procedural hurdle is that no adverse determination has been made against the city. My response is, that's great. No adverse determination has been made against the city. The city hasn't been found responsible for any misbehavior to this point, and maybe eventually they'll pack up their tent and go home, and there'll never be an adverse finding. Now, if that happens, you'll never have something you can appeal of right, but that's a good thing because you haven't lost anything. I mean, you've lost time and money, but you haven't been found culpable in any way, shape, or form, right?
Except in the court of public opinion.
Well,
These actions remain outstanding. They're picked up routinely by the media when they first are filed. And periodically we have another, it's been a year since so-and-so did X. We have another story on it. So we are being tried in the court of public opinion, and that brings more lawsuits to the city.
I know, I get that. I understand that, but that's like saying that if people go out and call a press conference and criticize my decision, that I can go to the Court of Claims and get an injunction to shut those people down and stop them from talking. I mean, it's the nature of things. I mean, we all must bear certain costs and burdens.
We should, we all do, but there should be a limit. And there should be a guarantee of due process for respondents in this process. And right now, there are no procedural limits that protect us in any way, shape, or form.
Okay, I got it.
Okay.
Thank you. I'll give you each one more chance if you want to say anything more. Ms. Pendrick, anything else you want to say? Okay.
The issue of due process has been brought up. There's no allegation in this complaint about due process. So that's not before this court. Even if it was, due process requires notice and an opportunity to be heard. And that's exactly what you get in the administrative process. Once the charge is issued, they'll have the ability to go before an ALJ and present their evidence. So
Right.
there's not a due process.
Right, and
concern
it
before.
certainly doesn't rise to the level of a substantive due process violation.
Yes, right. Excuse me.
Unless we're stretching substantive due process way beyond the breaking point.
The other issue that I wanted to touch on is the cases they cited outside of this jurisdiction for borrowing statutes. The courts borrow all the time from applicable statute of limitations when there is no statute of limitations. We did it in the Elkrook, right? The Mayor case is the one that said 3 years to file an Elkrook claim. But we can't ignore that there is a statute of limitations for an administrative process, and it's 180 days. So this isn't a case where we have no statute of limitations. This is just a case of not liking how long it takes to investigate a claim and get to a hearing.
And besides, as far as borrowing is other states doing, we have a very clear demarcation of the responsibilities of administrative agencies on the one hand and courts on the other hand. And I can't just throw out the window the constitutional framework that's been set up in Michigan just because I think it's unfair.
If there was a situation where there was not even a 180-day period and we were 7 or 10 years out, like the out of jurisdiction cases that they cited to this court, if it was that, you might have a laches argument or something else for the delay.
Right.
But you don't have an argument that we should just borrow from another statute to establish a trial date, which is in essence what they're asking this court to do, is to establish a trial deadline, not a statute of limitations to initiate a complaint with the NBCR.
Thank you, Ms.
Thank you.
Kendrick. Anything else, Ms. Fossil? Okay, thank you very much. As is my increasing practice, I'm going to decide this from the bench. I've got an enormous number of cases on my docket. I'm as prepared now as I'll ever be to decide this. Taking it under advisement and writing an opinion would be counterproductive. So I'm going to go ahead and take care of this one now. In this matter, we have a verified complaint that was filed with the court in 2023. And if you go through the verified complaint, you'll see that the core allegation is that in the course of an administrative proceeding, rather than a court proceeding, there has been an extraordinary length of delay in bringing these cases or these investigations or these claims to completion. I think it's best put in the plaintiff's response brief, where in the introduction on page 1, the plaintiff says, quote, "Plaintiff has brought this declaratory judgment action to establish that the 3-year statute of limitations, MCL 600.5805, which is applicable to claims brought under the Elliott-Larsen Civil Rights Act, also applies to formal charges of discrimination under the Elliott-Larsen Civil Rights Act brought in an administrative action by the Michigan Department of Civil Rights for decision by the Michigan Civil Rights Commission." And I can't think of a better, cleaner way to describe what this case is all about. The question is whether the Court of Claims can exercise jurisdiction. And in addition to that, there's a request to dismiss the case because of a failure to state a claim on which relief can be granted. Let me start out with the request for relief under Michigan Court Rule 2.116C4. That's the jurisdictional challenge. Summary disposition is warranted under MCR 2.116C4 when a court lacks jurisdiction of the subject matter. That's Wells Fargo Rail Corporation against the state of Michigan, 344 Mishap 351 at 358, a 2022 decision quoting Michigan Court Rule 2.116C4. Continuing, this court must resolve jurisdictional questions by determining whether the affidavits, pleadings, depositions, admissions, and documentary evidence demonstrate a lack of subject matter jurisdiction. So on the whole record before me, I will consider whether the Court of Claims has jurisdiction to address the request for declaratory relief here. The Court of Claims is a court of limited jurisdiction.
unlike a circuit court, which is a court of general jurisdiction. Now, I'm going to quote from a couple of cases that I think explain how I have to conduct my analysis here. I'm going to start with L&L Wine versus Liquor Control Commission, 274 Mishap 354 at 356, a 2007 decision from the Michigan Court of Appeals. If the legislature has expressed an intent to make an administrative tribunal's jurisdiction exclusive, then the circuit court cannot exercise jurisdiction over those same areas. As long as the statutory language chosen by the legislature establishes the intent to endow the state agency with exclusive jurisdiction, courts must decline to exercise jurisdiction until all administrative proceedings are complete. Now, that defines the relationship between agency proceedings and circuit courts. It doesn't deal with the relationship between agency proceedings and the Court of Claims, but it does make very clear that the courts themselves in general should stay away from administrative matters until they've run their course. Now, let's talk about the Court of Claims. In Council of Organizations and Others for Education about Parochiaid versus the State of Michigan, 321 Mishap 456 at 466, a 2017 decision, the Michigan Court of Appeals said this, quote, "The Court of Claims is a court of legislative creation. Its statutory powers are explicit and limited. The Court of Claims is a court of limited jurisdiction which does not possess the broad and inherent powers of a constitutional court." So, with that in mind, let me talk a little bit about the argument of the Court of Claims' ability to hear this case. It is certainly true that in the Court of Claims Act, the Court of Claims is vested with the authority to grant declaratory relief in an appropriate case, albeit against some sort of agent or instrumentality of the state. But in MCL 600.6419 paren 5 close paren, our legislature has told us, quote, "This chapter does not deprive the circuit court of exclusive jurisdiction over appeals from the district court and administrative agencies as authorized by law." Fundamentally, this case to me is one where there is an agency proceeding in progress. It has not yet come to fruition. And its frustration, because the process had not come to fruition, the city of Grand Rapids filed an application for leave to appeal in the Kent County Circuit Court. But the Kent County Circuit Court, in orders entered on March 30th, 2023, denied the application for leave to appeal. Only after that happened, and the city of Grand Rapids was stymied through the ordinary avenue of appeal by the failure of the Kent County Circuit Court to grant an application for leave to appeal, did the city of Grand Rapids come to the Court of Claims. And that's telling, because the way in which this system is structured, there can be no doubt that if the proceedings initiated by the Michigan Civil Rights Commission had resulted in an adverse finding against the city of Grand Rapids, the city of Grand Rapids would have had an automatic right of appeal to the circuit court and then on to the Michigan Court of Appeals. The mere fact that the circuit court refused to take the case on an interlocutory basis, and then there was no final agency determination from which the city of Grand Rapids could take an appeal of right, does not mean that the Court of Claims becomes, in essence, a court of last resort to which the city of Grand Rapids can go to seek the very same type of relief it was trying to get in the first instance from the agency, and then when that failed, from the Kent County Circuit Court. To my mind, this is exactly the sort of situation contemplated
by MCL 600.6419 when, with respect to the Court of Claims, the legislature said this chapter does not deprive the Circuit Court of exclusive jurisdiction, not jurisdiction, of exclusive jurisdiction over appeals from the district court and administrative agencies as authorized by law. For that reason, I grant the motion for summary disposition of the defendants under MCR 2.116C4 because I find that the Court of Claims lacks jurisdiction to grant the relief requested in this case. But there's more. Moving on to the request for relief under MCR 2.116C8, the argument is made that the statute of limitations that the city of Grand Rapids would wish that the Court of Claims would enforce in the administrative proceedings constitutes a claim which is unsustainable as a matter of law. In El Khalil versus Oakwood Healthcare, 504 Mich 152 at 159 and 160, a unanimous 2019 decision from the Michigan Supreme Court, that court said, a motion under MCR 2.116C8 tests the legal sufficiency of a claim based on the factual allegations in the complaint. When considering such a motion, a trial court must accept all factual allegations as true, deciding the motion on the pleadings alone. A motion under MCR 2.116C8 may only be granted when a claim is so clearly enforceable that no factual development could possibly justify recovery. And I find that to be the case here. I'll explain why. The request by the city of Grand Rapids for declaratory relief asks the court to enforce in an administrative proceeding a statute of limitations provision contained not in the Elliott-Larsen Civil Rights Act, but instead in the Revised Judicature Act of 1961. Specifically, that provision is MCL 600.5805 (2). The statute in the Revised Judicature Act states, except as otherwise provided in the section, the period of limitations is 3 years after the time of the death or injury for all actions, and the key word there is actions, to recover damages for the death of a person or for the injury to a person or property. Now, our Supreme Court, at least on 2 occasions, has commented on the purpose of the Revised Judicature Act. First, in Connolly versus Paul Ruddy's Equipment Repair and Service Company, 388 Mich 146 at 151, a 1972 case, our Supreme Court said, the statute in question is the Revised Judicature Act. It was drawn, as defendants point out, by a distinguished committee of lawyers known as the Joint Committee on Michigan Procedural Revision. The purpose of the act was to effect procedural improvements, not advance social, industrial, or commercial policy in substantive areas. There's more about the Revised Judicature Act. In the case of Woodard versus Custer, 476 Mich 545 at page 611, a 2006 decision, in a concurring opinion written by then Chief Justice Taylor and joined by other justices, Chief Justice Taylor made the following observation. Our legislature's purpose in enacting the Revised Judicature Act, of which a particular statute is a part, was to set forth the organization and jurisdiction of the judiciary and to effect procedural improvements in civil and criminal actions. That, to me, indicates that the word actions refers not to administrative proceedings, but to court proceedings. And so I believe that trying to take the statute of limitations provision in MCL 600.5805 which is part of the Revised Judicature Act, and import that into an administrative proceeding is pounding a round peg into a square hole.
I cannot say that there is any legal basis to take a 3-year statute of limitations applicable to quote actions, close quote, and apply that to claims under the administrative scheme at issue in this case. So for that reason, I find that summary disposition on behalf of the defendants is also appropriate under MCR 2.116C8. And so I grant summary disposition on all claims before the Court of Claims under MCR 2.116C4 for want of jurisdiction and under MCR 2.116C8 for failure to state a claim upon which relief can be granted. Now, this, of course, will be a final order that resolves the last pending claim and closes the case. If I'm wrong in my analysis on these two issues, the Court of Appeals will surely correct me. And for better or for worse, Ms. Fossil, there is now a final order which is appealable. So without question, you can even step right over the circuit court and go right to the Court of Appeals. Okay? All right. Thank you very much, everybody. The briefs were extraordinarily helpful. The arguments were even more helpful. And I'm glad that I was so fully informed about this case. It was very well presented by both sides. And I thank you very much for being here in person and for your time and attention. Thank you. And we can go off the record. Okay. Thanks, everybody. Appreciate it.